So Plessy versus Ferguson takes place 13 years after the civil rights cases. And the landscape of the United States had largely changed. What we had seen during this time period is, despite the fact that the 14th Amendment very clearly reached state action, and we know that because the civil rights cases say that's the only place that the 14th Amendment reaches, a number of states began to pass laws which discriminated on the basis of race. These were known as Jim Crow laws. These laws basically issued in segregation. And it seems that the 14th Amendment, from the precedent set in 1883, if it was to reach anything, it would reach these sorts of state-based segregation laws, because the state is very clearly taking action. But in Plessy versus Ferguson, we find out that maybe the 14th Amendment doesn't even reach there. And the truth of the matter is the 14th Amendment absolutely does reach there, but the court was too conservative and cowardly to actually enforce the 14th Amendment in the way that it was written. So what are the facts of this case? So an individual by the name of Plessy attempted to board a blacks-only railroad car in the state of Louisiana. And the state of Louisiana had passed a law which required separate cars for passengers who were white and separate cars for passengers who were black. The way that the factual background goes as articulated by the court is interesting, and then there's the actual facts. So I'll give you one, and then we'll talk about the other. Plessy refused to sit in the black car of the railroad, and thus he was arrested and sent to jail. That's the facts as the court articulates them. Here's the real facts. Plessy was considered 1/8 African American. He was so, at least complexedly, not obviously African American that you couldn't actually discern by view that he had any amount of African American blood in him. Once you realize that, you then have to ask yourself, how did this issue take place? Because seemingly what would have happened is an individual who appeared white would have tried to board a white railroad car, and there should be no conflict. So how did the individuals know that Plessy was legally black? And that's a term that we should probably at least spend some time discussing, legally black. The way by which these laws attempted to quantify if you were black are absolutely absurd. But he was considered black by law because even only 1/8 of his heritage was African American. There was an interesting thing that happens during this time period. And it's an interesting piece of history to me, because I study issues of indigenous law. Like that's one of my areas that I work in. And states were in the South had such a high hatred embedded of African Americans that many individuals of the time period who did have African American heritage would instead claim that they were Native American, because it was the law and also society and culture viewed that as being less bad than being African American. And so therefore all of these Jim Crow laws wouldn't apply to these individuals who identified as Native American. The problem was this number of people who claimed that they were Native American and thus were not bound by law as being African American. Um, this occurrence created, largely in the South, a weird family tradition of a heritage of claiming that you were Native American without having any attachment whatsoever to any tribe that existed within the area. Um, Very often, individuals who are sort of my parents' age will claim that, you know, way back their great grandmother was a member, and it's almost always of the Cherokee tribe. That's absolutely almost always not true. They weren't, but at least on census records, they were claimed as such because being of Native American descent was better than being of African American descent. So what all of these individuals who are claiming that our lineage ties back to Native Americans, what they're actually saying, most of them are actually saying, is that our lineage ties back to African Americans, not Native Americans. And that's what institutions of discrimination have done in the United States. So that's why we talk about in Plessy versus Ferguson that this individual was 1/8 Black, because that's how much the states cared. That's how much the states hated African Americans and wanted to regulate against them, is that you literally measured the content of an individual's blood to determine whether they're African American or not. So despite the fact that Plessy basically presented as a white dude, because he had this tiny bit of African American heritage, all of these Jim Crow laws, including the one in question in this case, applied to him. So how did the railroad find out? Plessy told him. Plessy told the railroad. And the reason why they did that is because Plessy and a group were attempting to challenge these laws as unconstitutional via the 14th Amendment. Because a basic reading of the 14th Amendment would say all of these laws are unconstitutional. All of these Jim Crow's laws are in violation of the 14th Amendment. The problem is Plessy and others who urged this occurrence to take place really misunderstood the Supreme Court at the time. And so they really got their least favored outcome by bringing this case to the Supreme Court, because their least favored outcome ultimately is seeing this separate but equal sorts of laws that existed in Louisiana and other southern states and actually make them nationalized precedent. Well, that's exactly what happened. The Supreme Court gives their stamp of approval to separate but equal laws, when in actuality, Plessy only brought this case, in fact, only told the railroad that he was 1/8 African American, because he wanted to challenge the legality of these laws. So worst case outcome. So the issue in this case it is very simple, is whether these separate but equal laws violate the 14th Amendment Equal Protection Clause. And by a 7-1 decision, the Supreme Court says no. That the 14th Amendment applies to legal distinctions. And in this case, there is no legal distinction made, because the two races are treated equally, even if legally separated, because Plessy could have used the railroad if he had boarded the African American car. So the accommodation was provided for him. Even if it was separate, it was still there. And so if, for example, African Americans could not avail themselves of the judicial system, that would be a legal-based distinction, and Louisiana would run afoul of the 14th Amendment. But in this circumstance, that's not the case. The law merely justifies separate but equal accommodations. It's not a legal status. And because it's not a legal status, the states can regulate in that area. It's a valid exercise of the state's power. The 14th Amendment doesn't exist to make the races socially equal. It exists to make them legally equal. And so the 14th Amendment can't read into this social milieu because a legal distinction has not been made by the state. So Justice Harlan loses his shit. And this is the famous Harlan dissent. This is why he is known as the lone dissenter. This is why Justice Harlan is remembered. And he starts out by calling the majority to task. And he says that our Constitution is colorblind and neither knows nor tolerates classes among citizens. So you can't, he basically says the Constitution doesn't do that. So you can't regulate it in the states. And if anything, the 14th Amendment so clearly applies to this case as it's absurd that the court is saying it doesn't. He goes on to say that, in my opinion, this judgment today rendered will prove in time quite as pernicious as the decision in Dred Scott. Basically, Harlan casts a vow. He's like, you remember the decision the court made in Dred Scott? You remember how everyone, even immediately after it occurred, said that, wow, this is one of the worst decisions the Supreme Court has made. Well, he's sitting on the court and he goes, hey, you know what? You remember what happened in Dred Scott? You remember how horrible it was and the path it set our nation down? Well, you're doing the same thing right now. You're looking at the Constitution. You're looking at the language and saying that language that clearly appears to apply to this case doesn't actually apply. And you're coming up with this weird caveat system so the 14th Amendment doesn't reach separate but equal accommodations because that's a social distinction and not a legal distinction. That's absurd, Harlan says. That is absolutely no one who drafted the 14th Amendment intended it to mean that. And the reason why you're making this decision, the reason why you're doing this is to appease southern states. That's the only reason why. But the southern states are discriminating on the basis of race again. And the 14th Amendment exists to stop that. And you're not doing it. And you're setting a precedent that will strongly affect this nation for who knows how long into the future. And it turns out Plessy was very, very right, because it takes 60 years from this decision for separate but equal laws to be declared unconstitutional. So the precedent in Plessy versus Ferguson sets the stage for the civil rights movement as we understand it in the United States. And it does so based on a weird interpretation of the 14th Amendment that clearly does not deal with the plain text, clearly does not deal with the original intent of the people that wrote it, but really makes up a distinction in the Constitution solely to appease southern states who saw it as their basic birthright to discriminate legally against African Americans.